Professor Dyzenhaus, you are the 8th Goodhart professor that I have the pleasure of interviewing, and I'm very grateful to you for kindly agreeing to add to our archive. I hope that in this interview we can talk about your career, your early life, and then hopefully touch on some aspects of your scholarly work. You were born in 1955 in Johannesburg, and I wonder if you can tell us something about your early life in late 50s and 60s.
Right, so just one correction. I think that our birth dates have got mixed up in the question. So I was born in 57.
1957,
yeah.
Thank you.
And so I was born in Johannesburg and grew up in South Africa during the apartheid era. I had a kind of ordinary middle class life growing up in South Africa. I was made aware fairly early on that there was something rather strange about the society, because my mother was a political activist. She was engaged all her adult life in various liberal causes, and so I spent part of my early life working for one opposition party, which was then called, I think, the Progressive Party. My mother was an active member of an organisation called the Black Sash, and I took part from an early age in their protests and other activities. So I did have some sense growing up, which was rather different from most of the people I knew, that there was something fundamentally wrong with South African society. But that sense was somehow uneasily matched by a sense that everything was okay. And for the most part, I just lived my life as a middle-class kid.
Your mother was politically engaged, actively engaged. Was your father, was he a lawyer?
No, my father was a refugee who had happened to land up in South Africa, which was not the place he wanted to be. He was born in Poland. He's Jewish as was my mother, and of course as I am. And he managed to survive the war in Poland, then went to university in Paris, then tried to stay in London. English didn't want him to stay because it was very difficult to get permission to stay at that time, and somehow he ended up in South Africa. And he wasn't politically active at all, but he did have, because of his own experiences, a kind of visceral hatred of all kinds of nationalism. And so he had no time at all for the apartheid government, because he saw it as, in some ways, not all that different from the oppressive regime under which he had suffered. And so that also gave me a perspective about the place of whites in South Africa, which was rather different from most of my fellows.
You mentioned in the preface to one of your books that you mentioned your grandfather, Ludwig. He'd actually been shot during an occupation in Poland by Germans. Well, not necessarily by Germans, but he'd been...
Yeah, so he was shot by the Germans. So early in the war, he was taken hostage, along with around 20 other prominent Jews, because a Jew who had been found with a radio and imprisoned had managed to escape his imprisonment. So the Germans took these prominent Jews and said if the fellow didn't give himself up, then they would shoot the people they had taken. And of course he didn't give himself up, and so they shot the people they had taken.
Do you know how old he was at that time?
I'm very bad at dates, so I think he probably would have been in his early 40s, mid 40s.
So, coming back to your early life, growing up in South Africa, do you recall, I mean, there were many events that were very traumatic and very dramatic politically. Did any of these affect you particularly as a child, as a young boy, perhaps?
I think that I became fully aware of what was going on when quite late in my time at high school, and then even more when I became a student at the University of the Witwatersrand in the 70s. So before then I was aware of things, but they didn't really have much impact on my life, except in so far as I was pulled into my mother's various activities.
So the school that you went to, the high school, what school was that?
Well, I went to an unusual high school. So the school I went to was started the year that I began high school by someone who had been fired by the board of one of South Africa's private schools. So, as I'm sure you'll know, there is a system of private schools in South Africa which are kind of modelled on the English public school. And he had become headmaster of one of these schools, and his views were considered too liberal by the Board of Governors, so they fired him. So he decided to start his own very liberal school. And in the first year there were maybe 40 students over 4 years, and they were nearly all there because they had liberal parents who wanted their children to grow up educated in a way that wasn't dictated by the apartheid system. So it was a school where we were, for the most part, taught to question things and not to accept something just because someone who claimed authority said that it was so. And that, I think, was when I first started to grow up properly politically.
Do you have any recollections of any particular teachers?
I had a couple of English teachers who really made a huge difference to me. So the first was a teacher who had come with the headmaster from the private school to the new school that the headmaster founded, and it was actually largely because of this teacher that the headmaster had been fired. So he had written a play together with his students which had allusions to sexuality, and some parents got wind of this, objected, and the board demanded that the headmaster fire this teacher, whose name was Brindley, and the headmaster refused, and that's why he was fired. So he brought this teacher with him to the school, which was called Woodmead. It was just outside of Johannesburg. And he actually didn't spend much time teaching us English. He spent most of his time arguing with us and trying to shake up our prejudices and preconceptions. Ironically, he himself he resigned at a certain point because he wrote a play together with my class, which was very atheistic in tone. And the headmaster, a man called Stain Cricker, although he was kind of white political radical by the kind of common lights of the time in South Africa, was a deeply religious man. He was, and this was not uncommon in South Africa, a deeply devout Christian with radical political views. And he did not like the kind of unrelenting atheistic line in this play, and he insisted that Brindley and the class who was writing the play with him take a more balanced approach. And Brindley refused and resigned, and that was the end of Brindley, which was not a good thing, but the one benefit of it was that he was replaced by another wonderful English teacher who actually taught us some English, but in a very innovative way, and she was the best teacher I encountered during this time.
What was her name?
Her name was, probably still is, I think she's lived in England for a long time, Miranda Alcock.
So when you went to university, did you do English as a first degree?
Well,
You did a BA in 1977, you graduated?
Graduate, yes. So English was my main love, but I disliked the English department, as I discovered at the University of the Witwatersrand, so intensely that I dropped English after the first year. So they seemed to me to think that they were some kind of outpost of Oxbridge in South Africa, and with a few kind of token exceptions, all we studied was kind of English literature conventionally understood. And I just didn't like it, and I switched my major to political science, which I really liked. The political science department was one of the best teaching departments I've encountered anywhere.
Any particular lecturers that stand out?
Well, there are two main influences on me. Were a South African called Michael Newpin and an American called Sheldon Leader. And it was a strange feature of politics departments at the English-speaking universities in South Africa that they were dominated by Marxists. And somehow the government, repressive as it was, thought that academic Marxism was beneath its notice. So the big conflict in the department was between one school of Marxism, the Frankfurt School, and another which was an Althusserian French structuralist school. And this conflict played itself out throughout my undergraduate education, and it actually seemed to have real relevance to what was happening in South Africa. So this is really what excited me about being taught political theory the way that I was, is that even though we were reading very abstract texts for the most part, they did actually seem to explain things as they were happening.
And the seeds began to germinate for your later scholarly work, perhaps, through this initial exposure?
Well, like in South Africa, or at least at my university at that time, the main law degree was a second degree, as it is in North America, even though it was called an LLB. And the second degree took 3 years, but one could shave a year off by doing various law courses in one's undergraduate degree. So my two majors, the subjects I specialized in, were law and political science. And because the political science department was mostly a political theory department, in my 3 years of my undergraduate degree, I had this consistent combination of law and political theory. And when I went to law school, after I'd finished my undergraduate degree, what I really was interested in was the intersection of legal issues and political theory, and that's really where I've been working ever since.
During your LLB at Wits, were there any particular lecturers that stand out?
Well, the one, the lecturer who had by far the biggest influence on me is someone who I think is one of my predecessors as a Goodhart professor. Was John Dugard a Goodhart professor?
He was.
Yeah. So John Dugard really transformed my legal interests. So he, as you'll know, is really his international reputation is justly earned as an international lawyer.
Yes.
And the international law course he taught was wonderful because a significant component in that course was the dispute over Namibia and Southwest Africa. And we learned the kind of intricacies of this international law problem in a way that seemed to me to illuminate both what was happening more generally in international law, but also what was happening on the ground in Southern Africa. But because John thought that legal theory was really important for understanding the apartheid state, he took it upon himself, even though this wasn't his specialty, to teach jurisprudence. So again, we learnt jurisprudence in a way that made issues, very abstract issues in legal theory, seem directly relevant to what was happening in the practice of law.
Very interesting. So you graduated with your LLB in
79, I think.
79?
Yeah.
And I just wondered I know that you, the years from 1980 to 82, I'm not actually sure about. I know you became a lecturer in 1982, but in those intervening years, did you do your articles? Or?
Oh no, what I did was my army service for this.
About that.
Yeah, so
Really?
so I'd made the mistake, and my mother was terribly upset with me about this, of not going to the army straight after school. So the choice as I saw it was that if you wanted to stay in South Africa, as I did, then you had to go to the army.
Yes.
So there was another option, which was that you could do double the time of your army service in military prison, and military prison in South Africa was no picnic. So if I'd gone straight after school, I would have gone for just a year, but during the time that I was at university, they changed the compulsory service to 2 years. So I spent 2 years in the South African Defence Force.
And whereabouts were you posted?
Well, initially, because I was both physically fit and graduate, I was sent to an officer training school just outside of Pretoria. So I was put on an officer's course there, and I was destined to be a law officer, which was a pretty privileged way of being in the South African Army. I would have likely been posted to Pretoria afterwards. But I was thrown off the course at the end as a security risk. And at that point I was sent to a unit just outside of Johannesburg, where I spent some 14 months as a postal clerk.
So that actually was, in a sense, perhaps the beginning of your political engagement, that you actually, your national service could have been a lot easier.
Well, my political engagement began in while I was an undergraduate. I was an active person in student politics. I held office in the National Union of South African Students local chapter at the university, and I took part in that kind of student activity, took part in student protests. So I was, as it were, fully politicized before I went into the army, which didn't make being in the army any easier.
No.
And I think largely because of the people I was friendly with at university, most of whom were much more radical than I was. Some of them were already involved in African National Congress underground activities. The army was keeping a watch on me. Then they started opening my post, and then they used the pretext of a letter I'd sent to a friend in England as to throw me off the officer's course.
Interesting. So you then became a lecturer in, I think it was 1982, at Wits. You were a full-time lecturer for at least a year. Was this a happy time, an interesting time in your career? It was the beginning of your academic career.
It was actually a great time. So John Goodhart had just started the Centre for Applied Legal Studies, which still exists today, and does an interesting mix of academic work and practice. And he had brought people to the centre who were pioneers, as it turned out, in South African labour law, in human rights law. And there were also several people who'd been recruited to the faculty, who were only a couple of years older than I was, but who were deeply interested in the same sorts of issues. So in a way, it was one of the most intellectually exciting times of my life.
You didn't stay there for very long, and this was presumably because you went to Oxford to start your PhD. And I wondered if you could describe the circumstances of this very important change in your life.
So I could have proceeded lecturing at the University of the Witwatersrand, and in fact this is what I wanted to do with my life. But because I was interested in legal theory, and because legal theory was not a thriving concern in South Africa, I soon realized my limitations, and also that it wasn't the case that there were all that many people around that I could learn a lot from. So as I mentioned, John Goodhart had taught jurisprudence not because it was something he specialized in, but because he thought it was important that someone like him teach it. And the people who were engaged in legal theory were a bit like, for the most part, the English department at the University of the Witwatersrand. They were uninterested in the legal issues of apartheid. And I thought that I needed to do graduate work, which I couldn't do in South Africa, in order to continue as a South African legal theorist. So I had to resign my position because I wanted to go to England to do a doctorate, and there was no way that the university was going to give me 3 years off. But their understanding and my understanding was that as soon as I finished this doctorate, I would go back to South Africa. But I was diverted by falling in love with a fellow graduate student who is Canadian.
In Oxford?
In Oxford.
In Oxford.
And at the point where we decided that we should get married, we decided that we should do that without letting the issue of which country we were going to live in cloud our decision. So we got married, and then we started thinking about where we should live as we got to the end of our doctorates. And although my wife, who's a philosopher, was fully prepared to try life in South Africa, I was actually by that point very reluctant to let her attempt life in South Africa, because this was in 1987 that we were thinking about where to go, and there had been one state of emergency after another in South Africa, and it wasn't clear when this process was going to end. It actually seemed that things would just get worse. And I remember going, and this was actually a kind of turning point for me, going to a talk by a senior figure in the African National Congress in Oxford, who was then a minister in the first cabinet after the transition. And he, at this point, and it was 87, said that there was no cause for optimism in South Africa. He just could see things getting worse. And so we did decide to go to Canada.
I wondered about that, whether you felt that you just would not be able to function properly in South Africa, or whether perhaps you had met your wife at that point.
Yeah.
But obviously a combination.
I thought that I would function fine, but philosophy was in a terrible state in South Africa. Well, I didn't do philosophy at university because the philosophy department was much like the English department, and there really just wasn't a good academic place for her in the South African philosophy academy at that point. Besides the fact that she found South Africa appalling in a way that I didn't. So despite the fact that I think I was pretty clear-headed about how bad things were, she could just not take the thought of having a black person as a servant. And I used to say to her that if we go to South Africa and we set up home somewhere and people get wind of the fact that we are not employing a black person as a servant, we'd have a lineup a few blocks long of people begging for work. And she just couldn't take that kind of thought.
And so you decided to move to Canada rather than stay in England. Did you think perhaps England was too small, perhaps too claustrophobic?
So she actually would have been happy to stay in England. But for some reason, and I can't quite recollect whether I had a good reason or not, or quite what it was, I thought that it would be better to go to Canada.
And so you went to Queen's University, where you had an adjunct and assistant professorships from 19... But before we come to that, I'm sorry, I just want to touch on, you had some part-time lectureships while you were at Oxford, at UCL and Queen Mary College. did you do this to help fund your PhD?
No, not really. I had funding for the PhD, so that wasn't a problem. So one thing I omitted was that my first year as a graduate student in England wasn't in Oxford, it was at UCL.
Oh, I see.
And that didn't work out for various reasons, and I transferred to Oxford. But William Twining, who was then the Quain Professor of Jurisprudence at UCL, got me to teach there, I think during my year in London, and then I taught there subsequently. And because of that, when there was a vacancy for a part-time person at Queen Mary, they asked me to fill that spot. And I did it mostly because I enjoyed the teaching. I missed not teaching as a graduate student, and although the extra money was very welcome, it wasn't primarily for the money that I did it.
So what did you teach?
I taught legal theory.
Legal theory. And you just commuted from Oxford?
Yeah.
Yes.
And I found it to actually have a very nice break from
yes.
having to steel myself to do my own work.
The one informing the other.
Yeah.
Yes. So you moved after your PhD to Queen's University at Kingston, and after that you were given an assistant professorship of law and philosophy at University of Toronto. So before we look at that, at Kingston, were you a lawyer or were you a philosopher?
I was something more complicated than that. So the philosophy department recruited my wife into a full-time position straight out of her PhD. And so the question arose what to do with this person who now gets called the trailing spouse. It was called something less flattering in the past. And Queen's put together a one-year contract for me. But because they didn't really know what to make of me, they actually shared me out between law, philosophy, and sociology. So I had 3 academic homes in my first year there.
And you taught?
I taught in law. I taught a course on the rule of law. In sociology, I taught a course on the social theory of Max Weber, someone I've always been interested in. And in philosophy, I think I taught a kind of straight legal theory course.
So when you moved to Toronto and you had this assistant professorship of both law and philosophy, it was at this point that you began to make steady progression up the academic ladder, and you used this time to write up your PhD in what became your first book, which was the Hard Cases in Wicked Legal Systems. And I wondered if you could sort of summarise for us in a nutshell what your main conclusions were and the circumstances of writing up this important work.
So from the time that I was starting to learn a little bit about the law, what puzzled me about South African law was that despite the fact that a highly oppressive government had been in power for a long time, was completely unembarrassed for the most part about the way that it used law as an instrument of its racist policies, and had complete control over Parliament. Despite all of that, somehow law did provide some kind of resource for resisting apartheid law. So it was possible throughout apartheid, even during the worst days, to bring legal challenges against the manner in which apartheid law was being implemented. So it was also the case, there's an important detail that I left out, there was no written constitution with an entrenched Bill of Rights that judges could use as a resource. So all they could use was really the resources that are familiar to lawyers in the common law tradition. And the ability to continue to exploit these resources, even at the worst times, fascinated me. And when I went to England, what I wanted to work on was whether one could make legal philosophical sense of the persistence of these resources in the face of a government that seemed all powerful and was doing its best to get rid of these resources. And so what I concluded is that these resources, which I suppose one could say are resources that conduce to the protection of the liberty and equality of all those who are subject to the law, that these resources are in a way necessary components of any legal order. And to the extent that a government succeeds in getting rid of these resources, it actually moves to a different mode of government, that is a mode of government different from governing according to law.
Do you feel that having grown up in South Africa and experienced much of what you described at first-hand account gave you more insight than, for example, somebody who would have been writing about these matters at remove?
Well, yes, I think the answer is that I did think and do think that if you grow up in a place like South Africa, you do have a different sense of the impact of issues such as the issues I was working on what happens in people's lives.
Looking back over the last 20 years since apartheid was dismantled and some of the worst excesses have been removed, do you feel happy with the way things have gone?
Well, I still have family and very good friends in South Africa, and I've noticed over the years that, and this might be true of other South Africans who've lived abroad, that I tend to be much more optimistic about South Africa than my family and friends are. That is, I still think that it's a rather large miracle that this transition happened at all. And despite all the really glaring flaws of ANC government, particularly in the last few years, it still seems to me to be a place which has a future, and it's certainly a lot better than the past.
Yes. Your thesis that positivism is destructive of the health of legal practice is based on the common law jurisdiction, in truth, a mixed system. And I wondered whether you'd looked at any other systems to see if this is a general rule, for example, USSR or Sharia law.
Well, the only other legal order I've studied in some detail, which is the topic of my second book, is the legal order of Weimar. So I was always interested in German social and political theory, an interest that came out of my education in the political science department at the University of Witwatersrand. And in one of the most important exchanges in legal theory in the 20th century between the great legal positivist H.L.A. Hart and Lionel Fuller in 1958, one of the topics they focused on was the legal experience of Germans under Nazism. So I'd always had a desire to find out more about these issues than one could learn from just this brief exchange between Hart and Fuller. And so I put quite a lot of effort into making it possible for me to go to Germany for a year in order to do research into Weimar legal theory, which I knew almost nothing about other than I thought it would be interesting.
And this was, I think, in 1992 when you were a Humboldt Fellow.
Yes, I was awarded a Humboldt Fellowship, and I was in Germany from, I think, probably August of 92 until July of 93.
And you were able, presumably, to gather data during this time for your book.
Well, what I read was a lot of German constitutional and political theory, and learnt about some of the legal issues that arose, especially in late Weimar, as the Weimar political and legal order was disintegrating. And the book explores, as did my first book, the issue whether their implications for political and legal theory from what happens in actual practice.
I obviously had to depend on reviews to get some sense of your work, of your scholarly work. And I looked at a review by Professor Julian Rivers from Bristol. And one of the points, an interesting point I thought that he made, was that when the new German constitution was created after the Second World War, in his opinion, it was more influenced by the legal philosopher Sment than any of the three philosophers that you analyse. Do you think this is a fair point?
It might be a fair point. Julian Rivers is an excellent scholar, and he knows a lot about German constitutional developments after the war. I'm not really in a position to question his judgment on that point. It does seem to me that others argue that Kelsen was a significant influence, perhaps more significant than Sment. Kelsen was not only a great legal theorist, some people think, and there's justification for this thought that perhaps he's the greatest legal theorist ever. But he was not only a legal theorist, he was also a very prominent international lawyer. But in the 1920s in Austria, he played a significant role in designing the first constitutional court in Europe, and actually sat as a judge on that constitutional court. And his understanding of a specialized constitutional court, I think, was very important in the German deliberations about what kind of institutional setup they should have after the Second World War. The person who, the other two people I looked at in this book, Carl Schmitt and Hermann Heller, did not play much of a role. Schmitt was an enemy of liberalism and democracy, and in a way the German constitution was designed to preclude his kinds of arguments from ever having a real hold in German constitutional law again. Heller was a social democrat, and in my view, at any rate, a much better constitutional theorist than Schmitt, but he died in 1933, and his influence waned after his death, which I think is the major reason why he has little influence in Germany today, although there's something of a Heller revival going on at the moment, and is almost unknown in the English-speaking world.
As you know, we have a supra-European constitutional system in the making, and I wondered if there are any lessons from your theorists for this.
That I'm afraid I can't answer. Yeah, I could tell you what some of these theorists might have said. So, Schmitt thought that an authentic constitution had to express the values of what he called the substantive homogeneity of the people. A very dangerous and nasty idea in the context of late Weimar and then Hitler's rise to power. He had there was a period of a few years when he aspired to and actually became the chief jurist for the Nazis. And so he would have thought that this idea of a supranational constitution is completely foolhardy. Why? Because it isn't attached to any authentic conception of a people. And it's possible that Heller might have been similarly skeptical. Kelson, I think, would have had no problem with it at all.
Very interesting. So that brings us to your appointment in 1998 to the Professorship of Law and Philosophy at Toronto. Were there any special circumstances to this appointment?
Well, it's important to understand that in North America, becoming a full professor is just an indication that you're making the right sort of progress through the ranks. So you start off as an assistant professor. When you get tenure, you're promoted to be to an associate professorship, and indeed some law faculties promote people immediately to a full professorship after they survive the tenure process. In Toronto and at most other North American institutions, if you produce the right kind of research after tenure, you will, after several years, be promoted to full professor. So it doesn't, for the most part, bring you any greater status. It doesn't give you a bigger salary or any perks. It's just progress through the ranks.
So it didn't lighten, for example, your teaching duties?
No,
administrative duties?
Not in the slightest. And in fact, I probably was rewarded with much heavier administrative duties because I was both willing and I had established myself as a scholar. So my law faculty, and this is common, will try to avoid loading people up with administrative duties in their junior years, just because it's thought good to give them the space in which to get their research careers started.
Gosh, I'm not sure if it's the same system here. I sort of under the impression that at a junior level you do have to do a lot of
so I think things work almost in reverse here.
Yes.
And certainly at Cambridge and most other universities in this country, I think becoming a chair is a much bigger deal, right? Because in the past there were only a few named chairs. Then universities started creating personal chairs for people. There are some universities, I think the LSE is kind of leading the charge here, which are trying to switch to the North American system.
Really? So during this time, from 1992 to 2008, I know 1998 you became professor, you've had several sabbaticals, and we've spoken briefly about your time at Heidelberg. You also came to Cambridge in 2006, and then you went to New York in 2008, but that's in the future. So in 2006 you were the Herbert Smith Visiting Fellow at Pembroke, and I just wondered what the circumstances were in that regard.
Why I ended up in Cambridge?
How did you come? Yes.
Yeah, so this is actually my third time in Cambridge. So I can't remember exactly the year I was here before, but I would have been about in the late 90s, I think. Or maybe even in the early 2000s. So in Toronto, one can take one sabbatical in two segments. So instead of having a full year, which one's entitled to in one's seventh year, one can take 6 months in one's fourth year and then 6 months in one's seventh year. And because we have a very long summer where we have no teaching duties, really 3 months off teaching duties, that means one can get 9 months away. And so I did that twice in Cambridge. And the reason that both my wife, who's a philosophy professor at the University of Toronto, and I wanted to come to England was that we really like England. And we have friends here, family here, lots of good academic contacts. And we both thoroughly enjoyed our time in Oxford. The reason that we came to Cambridge is, for me, in large part academic. It's because of the presence of Trevor Allen here. He's one of the people I've worked very closely with over the years. But it's also personal in that two of our closest friends from graduate school, who are a couple, have lived in Cambridge all this time.
So do you find that Oxbridge is conducive to the work that you undertake, particularly so in terms of the resources?
Well, what are the resources? The books and journals one can get anywhere. So it's people to talk to, and in a way there are more people, not only in Oxbridge, but at places like the LSE, Glasgow, all over the UK, that I find I have a great deal in common with intellectually. There are more such people in the United Kingdom than there are outside of the United Kingdom. So it's really valuable for me to be here, and when people learn that I'm here just because it saves them the cost of a transatlantic airfare, I get lots of invitations to speak, so I go to places and learn new things. And so in that way, it's really fruitful for me to be here.
Yes. Now, you published your book on judging the judges, also in this time frame that we're just dealing with now, or time since you became a professor at Toronto. This was published, Judging the Judges, Judging Ourselves, in 1998, and this was based to a large extent on your own personal involvement in the Truth and Reconciliation Commission. And I wonder if you could describe the circumstances of your involvement, and you could perhaps summarize the conclusions that you came to in this very important book.
Well, my family and I had gone to South Africa on, both my wife and I had a 6-month academic leave. And I partly wanted to go there because we have friends and family there. But also I wanted to actually see what it was like to live in South Africa again. I wasn't hankering after going back, but I was just interested to spend several months in the new South Africa. And my academic project at the time was to work on the privatization of the state, with no particular reference to South Africa. But it so happened that the Truth and Reconciliation Commission was in the middle of conducting its hearings during the time that we were in South Africa. And friends in the legal community told me that the Truth and Reconciliation Commission, about which I knew very little at the time, was going to conduct a hearing into the role of lawyers and judges during apartheid. So we were in Cape Town on our leave, and the hearing was to be in Johannesburg. And I phoned one of the TRC officials in Cape Town and asked about what it took to go to the hearing. I just wanted to know whether I needed permission and when he heard that I was in South Africa and wanted to go to the hearing, he persuaded me to give testimony at the hearing, which I had no thought of doing. I just wanted to go and listen. And what became clear to me afterwards was that at the time that I phoned the Truth and Reconciliation Commission, Archbishop Tutu, who was in charge of the whole show, was engaged in a dispute with the South African judiciary, because he wanted the South African judges to come and testify at the commission, and the judges refused. Some of them made written submissions, but they thought that if they subjected themselves to the interrogations of the commissioners, their judicial independence would be compromised. And the person I spoke to at the TRC, whose name I forget now, anticipated that with the right kind of hints, I could be relied on to try to rip to shreds the South African judges' argument for not appearing at the commission. So they had me go first, and in this way try to set the tone for the rest of the hearing.
And I noticed that one of the reviewers of your book is a public lawyer here, Professor Christopher Forsyth, and he maintains that concerning your criticism of the judge's refusal to appear, he says that their action was understandable. He said that it might have split the new judiciary and the new modus vivendi, and he says that the judges swore to, and I quote, administer justice in accordance with the law and the custom of the Republic of South Africa.
Well, Christopher Forsyth and I have been disagreeing about legal theory for a long time. So when I first encountered him, both through his writing and in person, he was teaching at the University of Cape Town. And at that time, he was putting forward a positivist account of law and of the role of judges in a legal order. And this was an account so I was taught by John Goodhart, and I accepted his teaching should be rejected. So I always thought, and I've spent my career arguing, that when judges interpret the law, they are misled if they think that there's some matter of fact about the law waiting to be discovered. Rather, whatever conclusions the judges come to are going to be influenced not only by the legal materials that are at their disposal and that they have to take into account, but also by their views in regard to the ideal that they think that law serves. So I always thought there was a great deal more room to maneuver for judges in the apartheid legal order than Christopher thought. And the argument in my first book and then in the Judging the Judges book is that to the extent that judges failed to exploit this room, they were in dereliction of duty. And then the further argument I made to the Truth and Reconciliation Commission was that the old order judges, so the judges from the apartheid days, who refused to come to the commission, kind of compounded their dereliction of duty by refusing to come. I probably now wouldn't make that argument. I probably would be more sympathetic with Christopher's conclusion that it was in the interests of maintaining the legal order that judges refused to come. But I would have rather different reasons for getting to that conclusion.
Understand. That brings us to your fourth major work, which is the Constitution of Law, Legality in a Time of Emergency. And I wondered whether you could describe for us the circumstances of writing this book.
Well, the circumstances, in a way, go back to my earliest work on South Africa, because that work concerned not only the legalized system of racial oppression in South Africa, but also the system of security laws that were put in place to stamp out political opposition. And so I had, in the work on South Africa, written a great deal about national security law and the problems that arise when one designates people as terrorists and security risks and so on. And then when I worked on Weimar legal theory, these issues came to the fore again because in Weimar there was one state of emergency after another, especially in late Weimar. And then September 11th, 2001 happened, and suddenly North American legal and political scholars became interested in these issues for the first time: state of emergency, national security, and so on. I think these issues, of course, had been discussed at the time of the Second World War and during earlier crises, but for a long time there'd been very little interest in them in the North American Academy. And so in a way I was quite well placed to deploy arguments that I'd made in the past in an effort to understand what was going on in North America and elsewhere after 2001.
So this book was published in 2006, which would have been the time that you were visiting Cambridge, and I'd wondered whether you were using that time in Cambridge to finish off your book.
I think it might have been finished before I came to Cambridge.
Right.
Because I was invited, and this was just fortuitous for me, to give a series of lectures here. So there is a series of lectures named in honor of a South African and former Chancellor of this university, Jan Christian Smuts. And I think it's not tied to law, but there is a fund available to bring a lecturer to Cambridge to give a set of lectures on, broadly speaking, let's say, Commonwealth themes.
I see.
So I had been working on various topics to do with states of emergency, security issues after 2001. And I decided to use this opportunity that the invitation gave me to produce a manuscript on which the lectures were based, and then could be revised in light of the reception that the lectures got for a book.
One of the reviewers, Dr. Agata Fijalkowski at Lancaster University, made a point which I thought was rather interesting. She said that you imply that the UK has a permanent state of emergency and is abandoning the rule of law. And she makes the point that there isn't redress at the Court of Human Rights because it deals only with personal liberties. So I wondered whether you thought that the Court of Human Rights could solve this problem by addressing areas of communal liberties, because this would take the issues out of the hands of the state at a stroke.
Yeah, so I'm not sure I even saw that review, but just a little bit you've reported of it makes me worried about what I thought I was saying in the book, because I certainly didn't intend to make that kind of claim. In fact, when it comes to the United Kingdom, the book, as I recall, tells quite an optimistic story, because it tries to show that despite some missteps, generally speaking, the judiciary here was furthering the project, which I call in the book the Rule of Law Project, and actually doing a much better job of it than their counterparts in the United States of America and in Canada. And I saw a very helpful set of exchanges between, at that point, the House of Lords and the European Court of Human Rights. So I thought that things were actually moving in the right direction if one's a rule of law enthusiast, as I am.
Right.
So the book was meant to issue some kind of warnings about going down the wrong path. But as I recall, generally speaking, I thought that here the judges, in conjunction with other institutions, were steering things in the right direction.
Right. Currently, you are the Goodhart incumbent in the Arthur Goodhart Chair of Legal Science, and I wondered how you felt up to now. Your time here has been. Have you found it very fruitful for your research? Could you tell me something about your experiences in this chair?
Well, as I was saying to someone as I bumped into on the stairs coming in today, one of the IT people here, he said to me, it must be the case that 3 or 4 months of your time here is up. And I said that these were just the words that strike fear into my heart, because at the moment I never want to leave. So the experience so far has just been wonderful, and I trust that it will continue that way. So I can try to tell you what I think the ingredients of this sense of things being wonderful are. So, first of all, the Goodhart chair is a great idea. One gets a house that is remarkable just outside of the city centre, which makes life here really comfortable. The walk from this house through the meadows to the law faculty is one of the most stunning walks I've ever been on. So it just gives me pleasure to go to work. And there's a very generous stipend given to the professors, so one feels materially well off as well. And then one's in Cambridge, and I have the access I described earlier to colleagues both here and elsewhere in the UK through being in Cambridge. Cambridge itself is, I've always found, somehow just a very fruitful place to try to think about the intellectual issues that I'm interested in. And then the time here is actually just the kind of time I like to have when I'm away from my home institution. That is, I don't have any administrative duties except for the editor of the University of Toronto Law Journal that I can't abandon, so I run it from here. But otherwise, other than that, I have no administrative duties, and I have a very reasonable teaching load, and I like to combine teaching with research. So the fact that I'm talking about issues that I'm interested in to a bunch of students at the same time as I'm trying to work out those issues for them in their own right has always seemed to me to be exactly the right sort of combination.
And have you found the students receptive to your ideas?
Well, I taught last term I think it's called a half course to undergraduate law students. So that's 1 hour a week for 2 terms. It continues into this term. And I'm teaching a course on what's called the legitimacy of judicial review. Now this is not a course that's going to attract a lot of undergraduate students. I think there are 7 students formally enrolled in the course, and then some auditors. But the students who are enrolled are there because, as far as I can tell, they seem genuinely interested, very smart, willing to participate in the discussions in class. And we're about to start dealing with a set of topics which is going to be completely strange to them. We started off with debates in legal theory about the legitimacy of judicial review, but debates in the UK and in the USA, and even though they might not have encountered these writings before, these are debates which will not be unfamiliar to them from some of their law courses. But this term we're actually dealing with Weimar legal theory and the debate between Kelsen and Schmidt about who should be, as they termed it, the guardian of the Constitution. And this will take the students into completely unfamiliar territory, but from what I've seen of them so far, they're more than up for it. And then this term I'm teaching the second part of the LLM jurisprudence seminar with Trevor Allen. Nigel Simmons and Tara Halder taught it in the first term. And we're actually going to be focusing on, Trevor and I, on this exchange that I mentioned to you earlier, that is the exchange between Hart and Fuller about the Nazi legal order. That's the launching pad for our part of the course. This takes me back many years, but it's also brings me to topics that I'm still working on today. And while I haven't met this class yet, properly, our first session is on Monday morning. From what I've heard from both people in the class and from those who taught the class last term, they're a very engaged, smart bunch, so I'm greatly looking forward to them.
Well, that brings us to the end of this conversation, and I thank you very, very much for a truly fascinating account. I'm extremely grateful to you, normally there's a chance for me to talk to the Goodhart scholar, the Goodhart professor, at the end of their tenure in June, July or August. So I hope that will be possible.
Yes, I'll be here until the end of July.